is Tommy Ray Larkin. Mr. Larkin is present. He is represented by Mr. Justin Olson, who is present. The state is present, represented by Union County Chief Deputy Prosecuting Attorney Ryan Jolly. We're set for sentencing today. Mr. Olson, are you ready to proceed?
Yes, Your Honor.
Mr. Jolly is the state.
Yes, Your Honor.
Madam Court Reporter, if we are not done by 5 o'clock, just go ahead and sign off at 5 and we'll finish without the court reporter, please. Mr. Larkin, at the time of your arraignment on October 17th of 2022, you were informed that an information was filed charging you with vehicular manslaughter. At that time, you were advised of the potential penalties involved, your constitutional rights, your plea options, and the effect of exercising each of those options. You then pled not guilty to the charge. However, on April 7th of 2023, you appeared before this court and pursuant to the plea agreement with the state, you withdrew your previous plea of not guilty and entered a plea of guilty to the charge. Pursuant to the plea agreement, the state agreed to recommend 3 years fixed and 7 years indeterminate. The defense was free to argue the sentencing, but the court was bound not to impose more than the state's recommendation of 3 years fixed, 7 years indeterminate. After you pled guilty and ordered a pre-sentence investigation, a copy of that report has been furnished to me and I reviewed it, and copies should have been furnished to your attorney and the state's attorney. Mr. Olson, did you receive a copy of that report?
I did, Your Honor.
Have you had a chance to review that with your client?
Yes, Your Honor.
Mr. Larkin, have you had a chance to review that with your attorney?
Yes, Your Honor.
Has the state received a copy of that report?
Yes, Your Honor.
Are there any clarifications or corrections from the state?
No, Your Honor.
Any from the defense?
No, Your Honor.
Any objection to this court relying upon the contents of the report in fashioning a sentence?
No, Your Honor. No, Your Honor.
Mr. Larkin, at our last hearing, this court reviewed the PSI, reviewed the plea agreement, and came back into court and indicated that it was not going to be bound by the recommendation. At this point, I've also discussed the matter again further with your attorneys, and I'm going to rehear their arguments for sentencing and why I should accept the plea agreement, and once I hear those arguments, then I'll let you know what I'm going to do. Understood?
Yes, Your Honor.
Mr. Olson, are there any witnesses for the defendant?
Your Honor, he has a substantial amount of family that's here in support, as you can see in the courtroom, but no, not necessarily any witnesses.
All right. Mr. Jolly, any witnesses?
No, Your Honor.
Any victim impact statements?
Not today, Your Honor.
All right. Mr. Olson, argument, please.
Thank you, Your Honor. Your Honor, as the PSI shows, and as we put on the record earlier, obviously this is a very tragic event. There are a lot of facts, I guess, which are unknown, what exactly happened. And that, along with other types of cases like this, is how the state and the defense came up with this plea agreement. We'll go through some of the facts, I guess, for the court's information. So Mr. Larkin, Your Honor, was in Pocatello that evening. He had been at the bar consuming some alcohol. He had met with a friend. They had talked for a little while, and then he went to Jack in the Box. He then left Jack in the Box, headed back to his home in Fort Hall. So he drives up the interstate, I-15, goes on the exit as the court square, it loops around from the north, coming back over, and then he would head west to Fort Hall down the highway. He's driven that road hundreds of times, probably thousands of times, but obviously he has the muscle memory of knowing where to go. The victim in this case, well, and we were able to, during this case, find actually, he went down with family members to the wrecking yard after he was charged and was able to dig through the car and find the Jack in the Box receipt showing the time that he left Jack in the Box, which along with everything else that happened would have been fairly consistent with his time frame of when he would have got to about that area. The victim in this case is from Peru. He worked down in Pocatello. He had left work and apparently was traveling northbound according to the state's evidence. What we can't quite understand, Your Honor, is a couple of things. Number one, that as the victim supposedly was traveling northbound, he was in the left lane, or the passing lane. So if you're on the interstate, you're supposed to be driving in the right lane, in the driving lane. And if you're driving down the road in the driving lane, which you're supposed to be, and a car's coming at you, you would think you would go off to the right side. I mean, it's just natural to go off to the side. The state's experts, which we question, but if we take their version as correct, the accident happened in the passing lane, so in that left lane. If that's the case, then my client was driving down in the right lane, which would have been, if it was a two-lane road, his proper lane of travel. And the defendant, or the victim, was in the, would have been in the left lane of travel, which would have been the wrong lane on a two-lane road. There's also...
I'm finding out, but it wasn't a two-lane road.
No, it's not a two-lane road.
Okay.
But what we can't understand is why that early in the morning, roughly 2 o'clock in the morning or so, if there's nobody else on the interstate, why would you be driving in the passing lane? You're supposed to be in the right lane. And why would you, if you see a car coming at you, if you're not impaired in some fashion, why would you not brake if you see an interstate and you see a car coming at you? Why would you continue to maintain your rate of speed? According to the evidence, it's my understanding that, and maybe I can find that, the speed, supposedly that they found my client had, I believe, hit his brakes in his speed. My memory was about 30 miles an hour at the time. 32? 32 miles an hour, 32 miles per hour at the time of the accident. So he was not driving fast. The victim was about 80, roughly 80 miles an hour. The victim didn't hit his brakes, my client hit his brakes. So if my client was the impaired one and the victim wasn't, well, my client hit his brakes and the victim wouldn't. There's just a lot of weird things. So we've got all of those factual issues, Your Honor, which are at concern and potentially could lead, obviously, to a jury finding reasonable doubt. And that's part of, I believe, the reasons why the state agreed to this plea agreement. I think the other factor, which is really...
Before you go on, I want to make sure I understand the argument, but regardless of who braked and who didn't and which lane, if your client hadn't been I-15 going the wrong way, the accident would have occurred.
That's correct, except for, Your Honor, we believe that it's entirely possible, but that my client was actually driving northbound in the proper lane, or going northbound on the interstate, and the victim had turned around and was coming southbound in the wrong lane. That's why my client was going slow, because he had seen a car coming, he had hit his brakes, and was trying to do something, whereas the other car just kept coming, which would have been in their lane of travel. Because we believe my client was going northbound, we believe the accident reconstruction is an error. Also, one of the witnesses that called in a car said it was going down the wrong way. There is some evidence that the color of the car that he saw was driving in the wrong lane, while going the wrong way, would have been the color of the victim's car. Now, obviously it's dark, they're in the other lane, so silver, gray, it could have been different white. So there is some independent evidence that potentially the victim was going the wrong way. Be that as it may, those are all factual issues that potentially a court or a jury would have to determine if we went to trial. Again, the problem is that we outlined before, my client, because of the accident and the injuries he suffered, which were very, very significant, Your Honor, he does not recall anything essentially from the time he left Pocatello going northbound because of his injuries. That's why the point was the Alford plea, because the evidence supports, and a jury could find his guilt beyond reasonable doubt based upon this evidence the state has, even though he can't admit to it because he doesn't have the recollection, and there's a possibility that it's not accurate. But that's the reasoning behind the Alford plea. As to the sentencing agreement, Your Honor, there was a similar case several years ago it just slipped my mind his name.
Dylan Gibson.
Dylan Gibson, who was charged. Again, he was intoxicated, ran into Mr. Hong's house. If the court recalls, Mr. Hong used to be the owned the Chinese restaurants throughout town, was a pillar of the community, made the best Chinese food around. But he was killed by Mr. Gibson. Those were much more aggravating circumstances. Mr. Gibson ran. There's some argument that he could have saved Mr. Hong because of the accident, but anyway, Mr. Hong ended up dying. And that sentence was a 3-year fixed sentence, obviously with an indeterminate portion. So we think that case is more aggravating. And I believe part of the state's position was it would not be fair to have my client sentenced to a longer fixed term than Mr. Gibson.
And that was obviously a different judge that sentenced him.
That's true, Your Honor.
And I'm not privy to the PSI in that case or what the processes were.
That's true, Your Honor. And I don't recall, our office was involved in Mr. Gibson's case. Mr. Blazer represented him. But I think there was a lot more aggravating factors. Obviously, the state has a lot more information than I do. My client does not have much of a record, Your Honor. And again, his score is a 9 on his LSI. Even the PSI, I think, supports the plea agreement of the parties. He has a minor. There's a driver's license charge from 2001. He does have the DUI from 2005, which is obviously some time ago. He has a consumption of alcohol, failure to present identification from 2005. He has another driver's license issue from 2005. Then has a DUI charge from 2006. So that was, what, 17 years ago? 18, 16? Maybe 15, 16 years ago. And then he has the DUI, the disturbing the peace from 2007. So he does have the 2 DUIs from 2006 and 2007, and then this case. So he has not had any record for 15 years. As the PSI indicates, again, he's got a very low LSI. And if we go to the numbers, which the department puts out, it says that their direct probation, that would be a 12.9% of recidivism. Rider would be 26%, direct term is 29%. So according to the department statistics, if we put Mr. Larkin, incarcerate him, there is a 1/3% chance that if he gets out, he will then become criminalized by being incarcerated. The recommendation on page 13 talks about one of the issues. He says there's very little remorse during the PSI interview, which we dispute because during the PSI interview he did say he felt sorry for the family, lost their loved ones, he felt sorry for his family for letting him down. He didn't want to be disappointed, he's sorry for the community. He's grateful for the first responders, he's thankful to nurses. Again, I think he showed remorse. And as the court's where many male people in our community have a hard time showing their feelings. So I think, knowing Mr. Larkin, I think that's quite a bit of remorse. And he showed remorse. He feels terrible about the accident. He's sorry a man lost his life. It's interesting that, all the letters that were in support, Your Honor, there were a lot of letters on how my client does, how he's needed in the community, how he's a good person, how this is, unusual. And it does say on page 13, Mr. Larkin has a good paying job and stable home. He's been sober, claims he's been sober since the crash, which is true. He does not feel he needs substance abuse treatment, but would participate. It appears as though he would make a good candidate for probation. Good candidate for probation. The lack of record, the lack of drug and alcohol problems, the lack of criminality with an LSI score of 9. This is a straight probation case, Your Honor, other than the fact that a man lost his life. That is the only aggravating factor in this whole PSI. And I'm not trying to minimize that. That is clearly an aggravating factor. a man lost his life. But if the court looks through all the factors, protection of society, rehabilitation, retribution, all of those except for punishment and deterrence to others would support a probation request and a probation sentence. So the PSI investigator respectfully recommended that Tommy Larkin be sentenced to a period of incarceration. Based on all those factors, Your Honor, I think the court should accept the plea agreement. I think that is well within everything, and I understand you weren't the case, Your Honor, but people should be treated fairly. The other case, and I understand you weren't the judge, but the other case, there were significantly more aggravating factors that my client doesn't have. I think it would look like he is being singled out for whatever reason and treated differently. The only factor I can see that's different between the other individual and my client is he's a Native American. And he shouldn't be treated any worse than anybody else for committing the same crime, especially when he doesn't have the aggravating factors of the other. And I would not object to the court taking, notice of that other pre-sentence investigation and seeing what the other defendant's LSI scores, whether there was a recommendation for probation. But I doubt there was for Mr. Gibson. So I think the court should accept the plea agreement. And I understand that a man did lose his life, and I think Mr. Larkin should pay back to the community.
Judge Pickett back in 2017 dealing with a similar case, although slightly more aggravating, did place Mr. Gibson in prison for a period of 3 years fixed and 12 years indeterminate. In that case, he was charged with both the manslaughter for operating a vehicle while under the influence. He was also charged with leaving the scene of an accident. And he did leave the scene, or attempt to leave the scene, after he crashed into the home. So that case is more aggravating than this case. The defendant didn't attempt to leave. I don't believe he could have, even if he had wanted to, but there wasn't any indication that he was trying to get away. So considering the two different cases, the maximum in this case is 10 years, Your Honor. The maximum in that case was 15 years. I believe that a sentence of 3 years fixed and 7 years indeterminate would be appropriate. It would take into consideration what's previously been done in Bingham County, although again, as we've all stated, it was a different district judge who issued that sentence, but sentences for similar crimes should, to the extent that it's appropriate, considering all the factors, should be similar. And I don't believe that in this case there are more aggravating factors than that other case that would justify the imposition of a higher sentence. As to why probation would not be appropriate, since that's been argued here today, I know the court will review all of the factors under 1925-21 as to why a defendant should be placed on probation versus being incarcerated. I would just note for the court that turning to the last few, a lesser sentence will appreciate the seriousness of the defendant's crime. Anytime there's a loss of life, that factor sticks out and weighs heavily on the state, as I know it does the court. I certainly believe that placing somebody on probation who was operating a vehicle under the influence would depreciate the seriousness of the offense that occurred. And then turning to deterrence, as is also mentioned in that section, imprisonment will provide appropriate punishment as well as deterrence to the defendant as well as those others who are similarly situated. Turning to why, some additional factors as to why imprisonment would be appropriate. As I've already mentioned, his blood alcohol content was a 0.125 and a 0.123. He did have prior DUI convictions in 2005 in Washington. He also had a previous DUI conviction in 2006 in Bannock County, as well as a DUI second conviction in 2007 in Bannock County. In that case, he was given 2 years of probation, and then his probation was revoked after a violation was found. In addition, the PSI does recommend prison in this case. I think that's appropriate. And as is already noted, his LSI is a 9, but I always take those with a bit of a question mark on DUI cases, because of the self-reporting aspect to that evaluation. You don't get to a felony DUI without having 2 prior offenses, and you don't get to a vehicular manslaughter when you're operating under a motor vehicle without some pretty serious issues in your past and some pretty serious alcohol problems. So for all those reasons, Your Honor, I believe that the court should accept this sentence. I believe it's justified and appropriate, and that it is also similar to other sentences in Bingham County that have been issued. And with that, I would submit, Your Honor.
Mr. Larkin, do you wish to make a statement on your own behalf?
Reading through some of the paperwork though, I don't know why they didn't do a full autopsy on the individual, but they did say drugs unknown on there. I'd like to point that out for the coroner's report or whatever that was reported. I don't know what else there is to say about this. I know this affected me very badly to where it scared me straight, to tell you the truth, Your Honor. It scared me to where I don't feel like I need to drink. I don't feel like I need to do anything. It kind of put my head back on place to where depression's no longer in my system as well. I don't feel depressed. If I feel sad, I actually just let it out. If I feel mad, I actually talk to those individuals that I'm mad at. I don't feel like I don't have anything on my shoulder anymore. I don't know if I had bad juju on me or what at the time of this whole thing, but being in the hospital and surviving through that and being in a place I don't ever want to be at, under those drugs and stuff that they put me under, I don't want to ever go through that kind of stuff ever again. And then also put my family, my parents are both hitting 80 years old. My dad's here right now. And I kind of noticed he's dwindling on his strength and stuff. And then my son, who's actually just starting as a freshman this year. And I just feel bad that I'm letting them down. I also let the person that lost his life and his family down. But I was actually hoping that they would be in court to where I could actually tell them I'm sorry about the whole situation. I haven't got to reach out to anybody of theirs. I don't know if they want to. I know that the PSI individual reached out to them and they haven't wanted to say anything on this whole situation. But I know if this was vice versa and my family would be here asking for justice and stuff the same. But I don't see his family here asking for anything, so I don't know what's the deal behind that. And I don't know what else to say, Your Honor.
Are you satisfied with the representation Mr. Olson has provided to you?
Until, yeah, yes.
Any issues with him?
Wish there was more communication. I just know he's a busy guy. He's always busy.
Do you have any complaints against his handling of your case here today?
No, Your Honor.
Do you know of any legal reason why I should not sentence you today?
No legal reasons. I would ask if I can get time to get all my stuff in line. I didn't know it was gonna be a straight sentencing today. I thought last time you said in court I had two choices, take your plea or take it to jury.
We're gonna talk about that here in a minute.
Okay.
Mr. Olson, any legal reason why I should not sentence him today?
Oh, Your Honor. Something I'm aware of.
Mr. Jolly?
No, Your Honor.
I'm going to outline a lot of factors here, Mr. Larkin, and go through this. As indicated before, I initially came in and reading this PSI and looking at things. I don't really disagree with what's been said here, especially when you get to the end of the PSI. If you take two factors out of your case, and this was a different charge, yeah, you probably would be looking at a probation period of time. When I sentence an individual, I have to consider the objectives of criminal punishment adopted by the Supreme Court. That includes protection of society, deterrence, rehabilitation, punishment. And I also have to consider the criteria under Idaho Code 1925-21. So the last time we were here, I initially told you I was rejecting the plea agreement, that we would come back and discuss it again and go forward. The attorneys have outlined the reasons why they feel I should be bound by the plea agreement. And I want to make it very clear on a couple of things. Number one, I have never sentenced an individual in any case based on race, religion, gender, or any other factor like that. I take the case as an individual, and I look at the circumstances surrounding that particular case individually. And that's what 1925-21 tells me I need to do. I need to look at those cases. You can be that are similar. Just because they're similar doesn't mean I have to treat them exactly the same. And so the parties have raised this issue of another judge sentencing another individual in similar circumstances, but arguably more egregious than what we're talking about here. At least, I shouldn't say more egregious, but there's more aggravating factors in that other case. And although I wasn't the judge on that case, I'm aware of some of those aggravating factors, and some of them have been discussed here today. And if my memory serves me correctly, that individual had a significant criminal history compared to yours. That's off my memory. I don't know if I'm correct or not. But just because a particular judge in that case sentenced an individual doesn't mean that I'm required to give you the exact same sentence. At the same time, we try to be consistent, given all the different facts that we have to evaluate. I told you that the PSI at page 13 says it appears as though you'd make a good candidate for probation. But then there's the but, and that is the fact that a man lost his life. And I think there's two buts. There are two significant aggravating factors in this case. Number one, a man lost his life. Number two, you have 3 prior DUIs. Granted, the last DUI that you had was a significant period of time ago. You're 38 years of age. This is your first felony conviction. Your LSI score is a 9. As Mr. Jolly outlined, that doesn't surprise me in a DUI case. Most alcoholics can function pretty well in society, and their LSI number is a lower score than what we typically see in other criminal cases. And part of that is because the LSI is really not designed for DUI offenders. There's other tools out there that are more accurate, but we don't use those for whatever reason. So I'm not surprised by the LSI. When I go through the PSI, there are some things that I'm not surprised at, and so they don't bother me a whole lot. In this case, there was an Alford plea. Mr. Olson explained what he believes are the contradicting evidentiary questions. The state seems pretty confident in their expert reconstructionist. I've not seen that report, so I don't know. But it seems very unlikely to me that the state's version isn't accurate. Regardless, you were under the influence at a high level, 0.125, 0.123. And despite having had prior convictions, you were back drinking and then getting behind the wheel and driving again, which puts everybody at risk. And unfortunately, in this case, it ended up costing another individual his life. Part of my problem when I initially looked at this, whether to accept the plea agreement, I'll be frank with you, when somebody loses their life and the maximum sentence is 10 years, is just, it blows my mind a little bit. But the maximum is 10 years for you. And so what is a proper sentence? I think I initially told the attorneys that I could probably live with 5 fixed and 5 indeterminate. They've given me some reasons to think otherwise at this point. But regardless, when somebody's life is taken, 10 years is not enough. 3 years fixed is not enough. 5 years fixed is not enough. But those are my limitations. I don't like to do a fixed maximum period in cases because I think an individual who comes out of prison needs to be on parole and has some supervision to help them reintegrate into society and get involved in any rehabilitative programs in the community setting as well. You've done some intensive outpatient treatment programs, done a couple of them at 4 Directions. The substance abuse screening, I'm not surprised with. Again, that indicates that you don't meet criteria for further treatment. I disagree with that because if you've got a 3rd DUI and then you end up driving a motor vehicle under the influence again, where somebody loses their life, there's still an issue that needs to be worked on. Because the chances are, statistically speaking, that it wasn't a relapse and you got caught or a relapse and got in this accident. It's probably happened more often than that. When I go through the PSI, I think that there is remorse. I think whether it's due to your intoxication or to the injuries that you sustained or a combination of both, it might be a little hard to comprehend for you and how to acknowledge that, and everybody grieves differently. So I'm not too overly concerned that there's a lack of remorse. I think there is. But at the same time, there's almost a little more emphasis on the fact that there are other victims besides just this man who lost his life. And that's your family. But those are the results of your decisions. So when I look at all of the factors under 1925-21, the objectives, as I indicated, whether it's 3 or 5, I don't think it's enough. But I'm more inclined today, based upon the arguments, to go ahead and follow and be bound by the recommendations, and so that's what I'm going to do. So I am going to be bound by the recommendation. Now the question is, you have asked for probation, the state has asked for incarceration. And based upon my previous remarks, as well as the factors that I've outlined, and considering those under 1925-21, a man lost his life. I don't think probation is appropriate in those circumstances because it depreciates the serious nature of the offense. It might have scared you straight, but that's not the lesson that somebody ought to learn in that fashion. This type of case also, it would diminish the deterrent effect, not only on you, but the community at large. Therefore, it will be the judgment of this court that you are guilty of vehicular manslaughter as outlined in count 1 of the information. You were sentenced to 3 years fixed, 7 years indeterminate. You're fined the amount of $4,000. Court costs are $245.50. Doesn't appear to, based upon what he pled to, that a driver's license suspension applies. That's what I was looking at. So, you understand the sentence, sir?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
Mr. Olson, have I complied with the plea agreement?
Yes, Your Honor, we just have one question for the court.
Okay. Mr. Jolly, have I complied with the plea agreement?
Yes, Your Honor.
Question, Mr. Olson?
Your Honor, my client, based upon the court's sentence, needs to sign some stuff at the school so his parents can have authority over his son while he's gone. School starts in the morning. He's got to get them on his bank accounts. We would respectfully request to be allowed to turn himself in at 6 o'clock tomorrow evening so we can get all those paperwork signed.
Mr. Jolly?
Your Honor, the defendant has made all of his court appearances since the outset of this case. There's been no failures to appear and no violations of law that I'm aware of, so I'm, under the circumstances, willing to agree.
Mr. Larkin, should have been ready to go today.
Well, school starts tomorrow, Your Honor, so
Well, I understand, but you should have been prepared today.
understood.
I think those documents can be brought to the jail and he can get those signed at the jail. So I'm just reluctant to do that because I'm afraid of what could happen if I follow the recommendation. So at this point, I'm rejecting that request. You'll be remanded to the custody of the Bingham County Sheriff's Office.
Did he get a furlough tomorrow, Your Honor, from about
No,
8 to...
I don't do the furloughs either. I'll just need to get the paperwork.
Your Honor, my son didn't come today because he didn't know this was sentencing. Like I said, I thought we were gonna push this to jury. So if I can at least get this 24 hours, I don't run from nothing. I haven't.
Yeah, my problem is I have a concern of whether you might go drink again, and then I got some
I
matters.
haven't drank
So you got plenty
anything
of,
for a year.
you got plenty of family here that can get the paperwork to you and get that taken care of, so the request is denied.
I'm just wanna help my son.
Not gonna argue again.
Or what if we made a deal where if he tests it and he hasn't consumed, you do it 5 years?
I'm not even taking, I don't have the authority to do that. So the request is denied. You have the right to appeal this decision. That appeal has to be filed within 42 days. You have the right to be represented by counsel on that appeal. If you cannot afford counsel, you can apply to have counsel appointed to represent you at public expense. Just remember, you only have 42 days. You may have the right to seek relief under Idaho Criminal Rule 35. That has to be filed within 120 days of entry of the judgment. And you may have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. That has to be filed within 1 year from the date your appellate time expires. You understand those time frames?
Yes, Your Honor.
If you have questions about how or whether to proceed with those matters, discuss those issues with Mr. Olson and he can advise you. Mr. Olson, anything else?
No, Your Honor.
Mr. Jolly?
No, Your Honor.
That concludes the court today. Court's adjourned.
Please rise.
Yeah.